Hello, my name is Kelly Burke. I chair Equity's Women's Committee. One of the priorities of the committee is tackling pregnancy and maternity discrimination in the workplace. So we're delighted to be collaborating on this video with Maternity Action for you to lead you through some of your maternity, pregnancy, and welfare rights. First, we have Katie Wood, who's the Senior Legal Officer for Maternity Action, and she'll be talking to you about those rights. And then it'll be followed up by Victoria Naughton from Equity's Tax and Welfare Service to let you know more about what benefits and support you have through Equity. So thank you for joining us. And with that, we'll turn it over to Katie.
Okay, well, thank you for the introduction. So I'm Katie Wood, Senior Legal Officer at Maternity Action. We're a charity that provides free advice on maternity and parental rights and benefits. And this webinar is especially for Equity members looking at your maternity rights. And so what we're going to be covering is starting with the two types of maternity pay, Maternity Allowance or Statutory Maternity Pay, questions about working during the maternity pay period and the possibility of keeping in touch days, the start of maternity leave and pay, some common questions, particularly during the pandemic, around health and safety during pregnancy. We'll also be looking at maternity rights for those who are employees taking maternity leave, and protection around dismissal and discrimination, and just wrapping up with a short look at maternity benefits. Now, what I'm going to be doing is covering the statutory rights. That's your minimum legal rights, and these apply by law to everybody. So if you were to be working and you tell your employer that you're pregnant and you're told, oh no, these rights don't apply to you, that's not right. These rights are legal rights. They apply to everybody. But of course, your entitlement to any individual right may depend on things like what your employment status is under that particular contract and whether you meet the qualifying conditions. And so we're going to be looking at the statutory minimum legal rights, what the qualifying conditions are, and who they apply to. So that will be determined by what your employment status is. Now, I know under your equity contract, Equity has negotiated certain additional rights, and we'll touch on those when those are relevant. And also, of course, you always need to look at your contract. You won't always have a written contract, but you may have a letter setting out your terms and conditions when you started a job. And if you have a written contract, or if your employer has a workplace policy or a handbook, you need to look at that to see whether it provides any additional rights that are better than the statutory minimum. So we're going to start with maternity pay and benefits. And so there's two types of maternity pay, statutory maternity pay and maternity allowance. And we'll look at each one individually, but they're both paid for 39 weeks. So that's a 9-month period. Statutory maternity pay is paid at a slightly higher rate for the first 6 weeks. You get nearly 90% of your average earnings, so nearly full pay. And then you get the flat rate, which is currently £151.97, or 90% of your average earnings if you earn less than £151.97 per week. Maternity allowance is paid at that same flat rate for the whole 39-week period. So £151.97 a week, or 90% of your average earnings if those are lower. Now, these rates apply until 5th of April this year, and then the flat rate is going to go up to £156.66 per week. Now, I mentioned sometimes you might get better contractual rights. And so you'd need to ask your employer or check your contract or your employer's maternity policy or staff handbook to see whether they provide anything better than that statutory minimum. And that's called occupational maternity pay. And some of the big employers generally will pay maybe full pay for a certain period, half pay for a certain period. but that's an employment benefit, and it's entirely down to your employer. You'd need to check the terms and conditions. Now, during your maternity pay period, obviously it's a very low rate. You may be entitled to other benefits, and that may include child tax credit if you're already claiming it. If you're not, you can no longer make a new claim for child tax credit. So you might be eligible for universal credit. And Equity are going to be providing more information later on in this webinar about claiming universal credit and other benefits you might be entitled to. So we're going to start with maternity allowance, and the reason we're going to start with that is because under equity contracts, you are classed as self-employed for tax and national insurance purposes. And so that means that your only maternity pay under an equity contract is to claim maternity allowance. Now, if you have 2 jobs, or you've done a mixture of work that maybe wasn't under an equity contract, you have another employed job, it's possible you might be entitled to statutory maternity pay under your employed job. But if your only work is as a self-employed, under a self-employed contract or an equity contract in which you are classed as self-employed for tax and national insurance purposes, then you need to be looking at claiming maternity allowance. So to be eligible, you need to have been employed or self-employed or a mixture of the two for at least 26 weeks out of the 66 weeks before your expected week of childbirth. Now, those 26 weeks don't need to be in a row. They can be any weeks at all, spread out across the 66 weeks before the week in which your baby's due. So that's about 1.25 years. It's quite flexible. You can go back quite a way to use any periods of employment or self-employment that you've had in order to be able to qualify for maternity allowance. And then you also need to show that you have average weekly earnings of at least £30 a week in 13 out of those 26 weeks of employment or self-employment that you're showing. And so again, doesn't need to be 13 weeks in a row. You can choose any 13 weeks. Now, the claim form and some notes about how to complete it and a calculator for working out that 66-week test period is available at the gov.uk page here, and you can download the claim form, print it out and fill it in, or you can ring your local Job Centre Plus and ask them for the claim form. Now, for the maternity allowance claim, as I've mentioned, you need to show 26 weeks of employment or self-employment. And remember that you can include any weeks at all, and it can include a mixture of different types of work. If you've worked for more than one employer during that period, then you can include any of those weeks as well. Now, you don't need to have worked for a whole week. Nobody's expected to work full time. If you have a week in which you just worked for one day or a part of a day, that counts as a week of work. So that will count as one of your 26 weeks. So make sure you include every single week in trying to count up those 26 weeks. Now, in order to prove your earnings, as I say, there's quite a low threshold, £30 per week. However, in order to get the maximum rate of maternity allowance of £151 per week, you need to send in pay slips if you're employed for 13 weeks with your highest earnings, because whichever pay slips you send in, Department for Work and Pensions are going to use those to work out your average earnings. So you want to maximise your earnings in order to be able to get the full rate of maternity allowance. So you need to send in 13 weeks of pay slips if you're employed, or that's 4 months if you're paid monthly. Send in 4 monthly pay slips. If you've got more than one job in any one week, you can add together earnings in order to push your earnings up. Now, if you're applying for maternity allowance on the basis of your self-employment, you don't actually need to prove your earnings. You don't need to send in pay slips. or invoices, anything at all that proves how much you earned. But what you do need to do is make sure that you have paid your Class 2 national insurance contributions for at least 13 weeks within the 13-week test period that you're using to claim maternity allowance. Now, if you've not recently submitted a self-assessment tax return, and if you've not recently paid your national insurance contributions, you can do that voluntarily if you're claiming maternity allowance. Excuse me. And it's very important to do that in order to get that full rate of maternity allowance. So you can contact HMRC, pay your Class 2 national insurance contributions, and you will be treated then as having sufficient earnings in order for you to qualify for the full rate of maternity allowance. If you haven't paid your Class 2 national insurance contributions, then you will automatically be paid maternity allowance at that very basic rate of £27 per week. But you do still have the opportunity then to pay your Class 2 national insurance contributions so that DWP are notified and will pay your maternity allowance at the full rate. Unfortunately, this causes quite a lot of delays for self-employed women. So if at all possible, at the point at which you're putting your maternity allowance claim in, it is worthwhile trying to update your Class 2 national insurance contribution record to try and speed up the process and try and get that full rate paid right from the beginning. If there is a delay, you're not going to lose out in the end, because once you are awarded the full rate maternity allowance, it must be backdated to the start of your maternity allowance period. So what's the position if you have an employed job and you may be eligible for statutory maternity pay? Obviously, there are some advantages to trying to qualify for statutory maternity pay if you're able to. Firstly, it's paid at 90% of your average earnings for those first 6 weeks, so you can get a significantly higher rate for the first 6 weeks of SMP compared to maternity allowance. Also, if you're claiming universal credit, it can be a huge advantage to be eligible for statutory maternity pay, because SMP is treated as earnings and it's largely disregarded when you're claiming universal credit. Whereas with maternity allowance, it's treated as another benefit and it's offset pound for pound. So you actually lose out on the majority of your maternity allowance if you are having to claim universal credit. So if you're working for an employer and you are paid through PAYE, through your employer's payroll with tax and national insurance deducted at source, you're treated as an employed earner, what we would call a worker or an employee. And that means you can be eligible for any sort of statutory payment. That could be statutory sick pay if you're off sick, statutory maternity pay, obviously for maternity leave. So this includes any sort of contract which is a 0 hours contract, whether you're a worker or an employee, an agency work contract, if you do bank work as a nurse or supply teacher, and some contractors and some gig economy work is paid through PAYE with tax and national insurance deducted at source. So if you have a contract like that, it's worth exploring whether you might be able to get SMP. Obviously, this excludes self-employed earners. So if you have an equity contract where you are classed as self-employed for tax and national insurance purposes, you're not going to be able to claim SMP through that contract. You need to be looking at maternity allowance instead. So the qualifying conditions for statutory maternity pay are much stricter than maternity allowance. It's not quite as flexible. It's quite a narrow period of time in which you're able to qualify. So this may not work for you. You may still need to go back and look at whether you qualify for maternity allowance. But it's really important, as I say, to look first and foremost at whether you might be able to get some SMP. So to get SMP, you need to have been employed by the same employer for at least 26 weeks by the end of the 15th week before your expected week of childbirth. You need to still be employed in all or part of that 15th week before your expected week of childbirth, and to have average weekly earnings of at least £120 a week in the 8 weeks or the 2 monthly period leading up to that 15th week before the week in which your baby's due. Now, as a rule of thumb, what that means is you need to have worked for the same employer for the first 26 weeks of your pregnancy to still be employed in that 26th week, which is the 15th week before your baby's due, and to have had average weekly earnings of at least £120 a week in the previous 8 weeks or 2 months. So that's roughly the middle of your pregnancy. It's when you're about 18 to 26 weeks pregnant that your employer will look at what your average weekly earnings were during that specific period. So as you can see, it's much stricter period in which you can qualify for SMP than for maternity allowance. So to find that all-important 15th week, there is an online calculator on gov.uk, or you find the Sunday before your baby's due and count back 15 weeks. And that will give you the start of that qualifying week for statutory maternity pay. And you must be employed in all or part of that week. As I've said before, being employed or working for only one day or part of a day counts. And if you weren't able to actually go into work because you were on annual leave or sick leave, perhaps pregnancy-related sickness, or previous period of maternity leave, or even going back to the furlough period, that still counts. You were still employed during any annual leave or sick leave. And so your average weekly earnings must be at least £120 per week. That's for the current tax year. So in fact, that should be April 2021 to April 2022. And that's going to go up to £123 per week from April 2022. And so if you're paid weekly, you need to look at that 15th week before your baby's due, count back another 7 weeks. And if you're paid monthly, you need to earn at least £120 per week in the last 2 months pay slips that you received before the end of the 15th week before your baby's due. And your employer, unfortunately, can only use the earnings that you actually received in that 8-week or 2-month period. So if you were receiving statutory sick pay, for instance, unfortunately, that's going to knock you out of being able to qualify for SMP, and you'll have to claim maternity allowance instead. The only exception is if you happen to be on furlough in that period. And in that situation, your employer must use your normal earnings, not the reduced furlough pay that you might have received. So what if you have just a fixed term or short-term contract? That may still be sufficient to enable you to qualify for SMP. If you work for that same employer for the first 26 weeks of your pregnancy, you were still employed under that contract in the 15th week before your baby was due, that's going to be sufficient for you to be able to get SMP, even if your contract's maybe subsequently going to come to an end. If you've qualified for SMP, even if your contract then ends, that employer must still pay you your statutory maternity pay. If the contract provided for any additional occupational maternity pay that topped up your SMP, perhaps to full pay or half pay, unfortunately, the occupational maternity pay is going to come to an end when your contract ends, unless you can negotiate with your employer to carry on paying that. If you're not entitled to SMP, perhaps because of the timing of your fixed term contract, then you look at claiming maternity allowance instead on the basis of your weeks of employment. And as you've seen, maternity allowance is much more flexible, and you can include employment in any of the 66 weeks up until the week your baby's due. including weeks in more than one job and where you've had gaps between different jobs. So maternity allowance is a safety net. It's a fallback. If you can't get SMP, then you can at least claim maternity allowance on the basis of employed or self-employed work. Now, on the maternity action advice line, we're quite often asked, can I do some work during my maternity pay period? It's only £151 a week. It's not very much. And in order to keep in touch with your employer to try and keep your work going, you may want to be able to accept a contract during your maternity leave period in order not to lose work in the future, and in order perhaps to top up your that very low level of maternity pay. So the rules are quite complicated, but we're going to work through it. So supposing you have two jobs, I think it's quite common in your type of work that you may have perhaps, you know, a variety of contracts and perhaps some sort of other part-time employed job as well between contracts. So you can get statutory maternity pay from any number of employers if you qualify for it in each individual job. So maternity leave and pay is separate for each employer, and you can start and finish your maternity leave and your statutory maternity pay on different dates. So that's very specific rules around SMP. If you've got more than one job, look individually at whether you meet the qualifying conditions for each employer. And if you qualify for SMP for more than one job, you can get SMP from each job for which you qualify. If you can get statutory maternity pay from one employer, but not from another, you can't claim maternity allowance to replace the SMP that you've lost from that other employer. You can only claim maternity allowance if you cannot get SMP from any job at all. As I mentioned, it's a safety net. It's to ensure that if you can't get SMP, you do have some form of maternity pay. So keeping in touch days, if you have an employed job and you're getting statutory maternity pay, you can do a keeping in touch day. You can work for up to 10 days without losing your statutory maternity pay. And keeping in touch days for an employer includes any work that you would normally do for that employer under your contract. It can also include things like training, going in for a meeting, getting in touch with your employer and colleagues perhaps in order to plan for your return to work. Any of this should be treated as a keeping in touch day. Now, unfortunately, even if you only work for part of the day, it's still going to count as a whole keeping in touch day. So if you agree to a meeting with your employer, it's only an hour, that will use up one of your keeping in touch days. And you can only use 10 keeping in touch days without ending your statutory maternity pay. Maternity allowance is a little bit more flexible, and we're going to come on and look at that in a moment. So keeping in touch days you can undertake during your paid or your unpaid maternity leave. So if you have an employed job, although the SMP only lasts for 9 months, you can take up to 12 months maternity leave. So that last 13 weeks, the last 3 months of unpaid maternity leave, you can in fact do some keeping in touch days with your employer. Now, the whole point, of course, of doing some keeping in touch days is to be paid, to do some paid work, to top up your maternity pay during that period. And unfortunately, the regulations don't specify how much you should be paid for a keeping in touch day. So it's very important to agree with your employer. Check if your employer's offered you a keeping in touch day, make sure you've asked how much you're going to be paid for that. You'd normally expect it would be your normal rate of pay, but don't assume. Always ask your employer, you know, if I come in for half a day or for this meeting to catch up, with everybody, or a specific piece of work that you've been asked to do. Check, it's going to be at your normal rate of pay, because obviously you might be paying for travel, parking, childcare, who knows. You want to make sure it's going to be worth your while. What you also need to do is ask whether, if you're going to be doing this work during your SMP period, is the pay for your keeping in touch day going to be on top of your weekly SMP payment, or is it going to be offset against your SMP, and how are they going to offset it? Otherwise, you could find, if you're not clear with your employer in advance, you could find it's not worth your while to do a keeping in touch day, and it is purely voluntary. Your employer doesn't have to offer keeping in touch days, and you don't have to agree to them at all. So it's only by agreement between you and your employer. Now, keeping in touch days, if you are self-employed and claiming maternity allowance, slightly different rules. And also, if you're employed but you couldn't get SMP through your employed job, so you're claiming maternity allowance on the basis of your self-employment. So the same applies in that you can do up to 10 keeping in touch days during a maternity allowance period without losing your maternity allowance. However, there is also some flexibility. So if you're self-employed, the Department for Work and Pensions ignores certain, what they class as sort of minimal maintenance and administrative tasks. So if it's not paid work, but for instance, you are just accepting or preparing for work after your maternity allowance ends, you're making arrangements to take up a contract at the end of your maternity allowance period. You're not being paid for that at this stage, and so that is classed as administrative tasks. So keeping your website up to date, doing your accounts, anything in which isn't part of your normal paid work should broadly be classed as these maintenance and administrative tasks. That's not a keeping in touch day. You've not been paid for it, and that shouldn't start to impact on your 10 keeping in touch days. But it's important, if you accept any paid work, keep a record of that and report it to Department for Work and Pensions on a regular basis. So you can do up to 10 keeping in touch days during your maternity allowance period without losing any maternity allowance. And that includes employed and self-employed work. Now, once you've done your 10 keeping in touch days, the Department for Work and Pensions should, they can disqualify you from your maternity allowance going forwards, but the disqualification should be reasonable in the circumstances. And what they should do is consider how many days you've returned to work for after your 10 allowed days. And they should be looking, for instance, at how that compares with how you used to work before your maternity leave period. Have you returned to your normal working pattern? If you have, it's likely you'll be disqualified from the rest of your maternity allowance. If you've only come back to work for part-time, or perhaps just a short period, you should only be disqualified from maternity allowance for a reasonable period. Now, maternity allowance, £151 a week, can in fact be reduced by 1/7 or 2/7, depending on how many days a week you're returning to work for. So if you used to work full-time, you're on a full-time contract up until the start of your maternity allowance period, you take about 6 months, and then you're offered a contract over a 3-week period. The first 10 days will be discounted as your 10 keeping in touch days. And then for that next week, it's likely you'll be disqualified from maternity allowance for that week. And then you should be able to go back onto your maternity allowance for the rest of your 9-month period. Supposing you have 6 months off work and then you're offered work 2 days a week over a 3-month period. And you need that work. That's going to be, really useful income to top up your maternity allowance. For the first 10 days that you work 2 days a week, that will be ignored as part of your 10 keeping in touch days. And then for the remainder of that 3-month period, when you're working 2 days a week, arguably, you should only be disqualified from about 2/7 of your maternity allowance payments. So you should be paid by your employer for doing that work 2 days a week. And your maternity allowance could be reduced by about £40, roughly. It's about 2/7 of the weekly maternity allowance period. So again, you should still continue getting some of your maternity allowance. You've not returned to your normal working pattern. As I say, keep a good record of the work that you're doing, report it to the Department for Work and Pensions on a regular basis. And if you are disqualified unfairly from the rest of your maternity allowance, do get advice, and you can appeal against the DWP's decision. So we're often asked, can I start work for a new employer during my maternity leave? Now, if you're claiming maternity allowance, either because of your employed or self-employed work, that's not really an issue. It still counts, whether it's a new employer or your existing employer. You're still governed by those rules around being allowed to work for 10 days and then having a reasonable reduction made to your maternity allowance. Obviously, if you're claiming maternity allowance and you get offered a full-time job towards the end of your maternity allowance period and you report that to Department for Work and Pensions, it's highly likely that's going to mean they disqualify you from the rest of your maternity allowance. But the rules are slightly more complicated if you have an employed job, you've been claiming SMP from that employer, and then during your maternity leave, you decide that you've been offered a new job, and that's likely to start during your SMP period. So as to whether or not that's going to end your SMP depends on whether you were employed by this employer in all or part of the 15th week before your expected week of childbirth. So if you're going to work for an employer during your SMP period and you were employed by that employer in the 15th week before your baby was due, that won't affect your SMP. And you can return to work for that employer during your maternity leave period and still get your SMP from the employer that's paying it. Now, if you've been offered a job by a new employer who didn't employ you in the 15th week before your expected week of childbirth, then if that's before the birth, you can actually work for that new employer and still get SMP. But after your baby's born, if you start working for a new employer, that will stop, that will end your SMP for the remainder of your maternity leave. And so you'd need to tell your old employer to stop paying your SMP. So we're going to move on to the start of the maternity leave and pay period. There are some quite strict notice requirements. So if you have an employed job, you must give notice to your employer of the date you intend to start your maternity leave by the 15th week before your expected week of childbirth, or as soon as reasonably practicable. And in fact, what that means in practice is that if you didn't tell your employer, if you didn't give them notice by the 15th week before your baby was due, and you suddenly go into labour, perhaps because your baby was premature even and you haven't reached that week, or you haven't yet given notice, your employer can't refuse maternity leave and pay. What you must do is tell your employer as soon as you can, I've given birth. That triggers the start of your maternity leave and pay period from the day after the birth. It can't be refused, in fact, under any circumstances. But of course, wherever possible, give your employer notice by the 15th week before the week your baby's due. Now, the important thing is, in order to get statutory maternity pay, you must give your employer the MAP-B1 maternity certificate. If you hadn't given notice on time, or you gave birth prematurely, you've told your employer as soon as you can that you've now given birth, and that's triggered the start of your maternity leave and pay. In order to get SMP though, you absolutely must give them the MAP-B1 maternity certificate. If possible, at least 28 days before the start of your SMP period, but in fact you have up to 3 months from the start of the SMP period at the latest, if you've got a good reason for why you couldn't give it in earlier. If you're going to be claiming maternity allowance, you can apply, you can send in that application form from the 15th week before your expected week of childbirth, so that's when you're 26 weeks pregnant. You need to state on the application form when you want your maternity allowance period to start. Now, ordinarily, it's up to you when you want to start your maternity leave and pay, and you put that date on your maternity allowance claim form, and you notify your employer, if you're employed, of when you're intending to start your leave. Now, if you're not employed, by the 11th week before your expected week of childbirth, then your SMP, or your maternity allowance period, will automatically be treated as starting 11 weeks before your baby's due. If you give birth earlier, obviously it will start the day after the birth, however early that is. If you're dismissed or your contract comes to an end between 11 weeks before your baby's due and the birth, then your maternity leave and pay will automatically start from the day after the date that your contract ends. Now, the latest that maternity leave and pay can start is the day after childbirth. You can never ask for it to be delayed any later. As I've said, you need to tell your employer or Department for Work and Pensions that you've given birth as soon as possible, because that's the date from which your maternity leave and pay will start to be paid from. If you haven't yet applied for maternity allowance, obviously put your claim form in as soon as you can in order not to delay payment. Now, there's one other rule about the start of maternity leave and pay, and that's what's called the 4-week trigger. And so if you are absent from work wholly or partly because of pregnancy in the last 4 weeks before your expected week of childbirth, your employer can automatically start your maternity leave and pay within that period, and DWP will automatically start your maternity allowance period. So that would be if you were off sick in the last 4 weeks before the week your baby was due. And it includes a maternity suspension. So if you were suspended on health and safety grounds in those last 4 weeks, that would be counted as absence from work, wholly or partly because of pregnancy. But your employer can't start your leave or pay or DWP. They can't start it any earlier than 4 weeks, unless, of course, your contract had already ended. Now, if you're employed and you and your employer had already agreed that you were going to start maternity leave, perhaps you were going to work up to the birth, maybe the employer's arranged cover, and you're off sick for the odd day of illness, your employer can in fact ignore that if they want to. And they can't take into account non-pregnancy related illness. So you're off sick with COVID, that doesn't trigger the start of your maternity leave and pay. You're still able to start it on the date that you've notified your employer or DWP. So we're going to move on now to health and safety at work during pregnancy. Obviously, it's been a very topical issue during the pandemic. Certainly our advice line has been flooded with calls in the last 18 months about these issues. So all employers must carry out a workplace risk assessment. That protects all of us at work. And the workplace risk assessment must specifically include risks in relation to pregnancy, for 6 months after childbirth, and risks in relation to breastfeeding. And this protection applies throughout your pregnancy, 6 months after the birth, and for as long as you're breastfeeding. Now, in order to get health and safety protection, you must notify your employer of your pregnancy in writing. That includes a text message, an email. Obviously important to keep that evidence as well. And once you've notified your employer of your pregnancy, they must look at that risk assessment. They must look at the specific pregnancy-related risks, and there is a legal requirement to individually look at your job, any health conditions, for instance, that you have, any medical evidence you provide, and they must take reasonable action to remove those workplace risks. And there's 3 steps they need to follow. Firstly, they need to look at, can they take reasonable action to remove the workplace risks, such as altering your working conditions or your hours of work? And that applies to all workers. And under your equity contract, although for tax and national insurance purposes, you're classed as self-employed, in terms of your rights at work, you are classed as a worker. And you have, that gives you this enhanced health and safety protection. It gives you protection against discrimination, which we'll come on and look at as well. Now, if it's not possible for your employer to make your workplace safe by these sorts of reasonable actions and reasonable adjustments, and we'll come on and look at some of the common health and safety risks in relation to pregnancy. If that's not enough, and if that's not going to make your workplace safe, then they need to look at whether they can provide suitable alternative work. And if there's no safe, suitable alternative work available, then they must suspend you on full pay. Now, those more enhanced rights only apply to employees and agency workers with at least 12 weeks continuous service through their agency. Now, if you're working under an equity contract and your contract is ended for health and safety reasons, it may be that you're told that you're not insurable, for instance. It's very important that you speak to Equity. They'll negotiate for your work to continue or for you to be paid for the rest of your contract. Now, the Health and Safety Executive's website, I've given you the link here, has information for employers, can be quite useful to forward on to employers, just to flag what their obligations are. It sets out the requirement for them to conduct a risk assessment and individually look at the risks in relation to your job and to make adjustments. And it sets out some of the common pregnancy-related risks that they should be taking action around. So obvious risks like standing or sitting for long periods, heavy lifting, but it includes things as well like working in extremely hot or cold temperatures, working long hours, heavy workloads, work-related stress. These are all pregnancy-related risks. And so that can be useful evidence to show your employer. Other useful evidence can be talk to your health professionals, your midwife, your GP, if you're concerned about risks at work. They may be able to reassure you, may be able to reassure your employer. They might be able to write you a fit note to say, actually, you are fit for work, as long as your employer makes, certain possibly quite minor adjustments. That will be sufficient to keep you safe at work and you can continue working. However, if your health professionals are more concerned, if you're more concerned, get advice on the risks. It may be that a letter for your employer or a fit note saying you will be fit for work if certain adjustments can be put in place. In other words, as long as you can avoid all heavy lifting, and the employer makes adjustments to ensure that you're not required to do any heavy lifting, you can continue to do your job as normal. That sort of evidence can be really helpful, reassuring for you, very helpful for your employer as well. Now, COVID-related risks, obviously, there's been a significant amount of guidance during the pandemic about the risks in relation to coronavirus and pregnancy. It's changed frequently. In fact, the latest I looked, it had changed again as of last week. So for clinical guidance on pregnancy and coronavirus, including vaccines and pregnancy, what to do if you or your family have COVID shortly before or after the birth, for instance. There's some really useful guidance put out by the Royal College of Obstetricians and Gynecologists, and I would take a look at all of the information that they have there for pregnant women and new parents. This is the clinical guidance that the government as well is relying on to advise on health and safety for pregnant women in the workplace and in relation to COVID. I've also given you the link to the government guidance on working for pregnant women during the COVID pandemic. As I say, the most recent changes have been made just as of the end of last week. And so their current guidance is that pregnant women are considered to be higher risk from 26 weeks of pregnancy. And as we've said, what the law says is that employers must assess risks in the workplace. That must specifically include risks to pregnant women, and they must remove those risks once they've been notified in writing of your pregnancy. And if there are risks in your workplace and your employer hasn't taken action to deal with them, or they've ended your contract, then you may well have claims for the loss of pay and pregnancy discrimination claims as well. So we're going to look at maternity rights for employees. Now, this obviously only applies if you have a contract for where you are classed as an employee. So that's more likely to be either a permanent contract, it could be full-time or part-time, but it could be a 0 hours contract, for instance, which would sometimes it will state that you're a worker, sometimes it will state that you are an employee and you have the rights that other employees have, even though you don't always have guaranteed hours. So as long as your contract says that you are an employee, you are entitled to certain additional rights. And so the first thing is that you are entitled to maternity leave. And the leave is the right to take a period of time off, in fact, up to a year off, and to have your job held open for you so that you have a job to return to at the end of that period. If you're not an employee, you don't necessarily have that right to have your job held open for you. And during that maternity leave period, you're entitled to all of your normal contractual benefits, apart from what's classed as remuneration, which is your normal salary or wages. And that's because that's replaced by SMP or maternity allowance, as we've looked at. The main right for most of us is our paid holiday. And so if you're an employee, you continue to accrue your holiday as normal during that maternity leave period, and you're entitled to be paid that holiday at the normal rate. So not your SMP rate, whatever is your normal rate of pay. If your hours fluctuate, that's likely to be an average of pay that's generally averaged out over a 12-week period, and that might be perhaps the 12 weeks before you stopped work, before your maternity leave. And you'd need to agree with your employer when you're going to take your holiday. You'd book it in the normal way, however you normally book holiday at your workplace. If you're not able to take your holiday because of your maternity leave period, if you get the statutory minimum of 28 days paid leave per year, then you must be allowed to carry that forward, or to take that as well as your maternity leave period. Holiday, the statutory minimum of 28 days paid holiday is a different right from maternity leave, and you are entitled to both rights. Obviously, if you work part-time, that's going to be prorated. Now, if you're on maternity leave and your role is at risk of redundancy, you have some additional protection in that you have the right to be offered a suitable alternative job if one is available during your maternity leave period. Now, obviously, if your whole workplace is closing down, that's not going to give you any additional protection from that of your colleagues. You will be made redundant alongside your colleagues. And as long as you weren't selected for redundancy, specifically because of your pregnancy or maternity leave, you can be made redundant during maternity leave, and you'd be entitled generally to any statutory or contractual redundancy or notice pay that you'd normally be entitled to. If you think you've been selected because of your pregnancy or maternity leave, get advice. That may well be pregnancy or maternity related discrimination and an automatic unfair dismissal. Now, at the end of your maternity leave, once your 52 weeks of leave has ended, or perhaps you've given your employer notice that you're going to return to work early, you need to give at least 8 weeks notice if you're not going to take the full 52 weeks. If you can only afford to take the 9 months paid maternity leave, then once your maternity leave ends, you are officially back at work. And obviously you do have to return to work unless you are resigning from that job. What happens if you're not well enough to return after the end of maternity leave? Well, you're entitled to take sick leave, just like any other employee. If you've taken holiday and you're not well enough to return to work at the end of your holiday, you'd call in sick, and you need to follow your employer's normal sickness reporting procedures. And you'd be entitled to any sick pay that you normally qualify for. If your employer provides fully paid contractual sick pay, that's fine. You're entitled to that if you're off sick immediately after your maternity leave. However, if you only get statutory sick pay, that can be slightly more complicated, and I would get advice on that. You'd only be entitled to statutory sick pay outside the SMP or maternity allowance period, and that means you need to call in sick after your maternity leave and pay period has ended. However, also to qualify for statutory sick pay, you need to have earned at least £120 per week on average in the last 8 weeks. If you've been taking the unpaid maternity leave, that means you can't get statutory sick pay immediately after unpaid maternity leave. But if you are going to need to take sick leave after your SMP period, that counts as earnings. And if your SMP was more than £120 a week, you can qualify for statutory sick pay. But do get advice. It is quite a tricky area. And so we're going to look at the protection that you have against dismissal and discrimination. So under the Equality Act, you have protection from pregnancy and maternity discrimination if you are an employee, an agency worker, or a contract worker. If you're working under an equity contract, you are classed as a worker, and you do have protection against discrimination under the Equality Act. Now, in order to show discrimination on the grounds of pregnancy or absence on maternity leave, you need to show that you've been treated unfavorably because of your pregnancy or your absence on maternity leave. You don't need to compare yourself with how anybody else was treated, whether that's how a man was treated on sick leave or how somebody who wasn't pregnant was treated. That's not relevant for pregnancy and maternity discrimination claims. But what you do need to show was that the unfavorable treatment was because of pregnancy, for instance, or because you are absent on maternity leave. And that's not actually quite as easy to show as it may sound, because you've got to show what was the reason for your employer's treatment. What was their reasoning in their mind at the time, for instance, that your contract was ended. And if they can show that there was a reason that's not related. So say you were on probation period and they had raised concerns about performance, and this had been well documented. They'd spoken to you about it, given you an opportunity to deal with any issues. Perhaps they provided further training, and they've then not extended your probation period and ended your contract. If they can show that that wasn't because of pregnancy, then that would defeat a pregnancy discrimination claim. If you can show that there were no performance issues raised and that they only started to raise this once you'd notified them of your pregnancy, then you may be able to demonstrate that was unfavorable treatment because of pregnancy. But as you can see, it depends on the evidence, and that can be difficult to show, and it's really important to get advice. If you are treated unfairly and you think that it's because of pregnancy or your absence on maternity leave, keep a good record of what happens. Make sure you've got a good paper trail around discussions. Keep any emails or written evidence that you have, and do get advice. Don't delay. If you're an employee, you have protection against unfair dismissal if you have at least 2 years service, and automatic unfair dismissal is a day one right if you can show that the dismissal related to pregnancy, childbirth, or absence on maternity leave. So for instance, if you work for an employer, you're on maternity leave, and you and a number of employees are being put at risk of redundancy. You've told your employer, I'm on maternity leave. You've identified a suitable alternative vacancy, and your employer hasn't offered that to you, as they should do under the redundancy protection that exists for women on maternity leave. Then you may have a claim for automatic unfair dismissal if you weren't offered a suitable alternative vacancy. So it's really important initially to raise it informally with your employer. If you've got concerns, talk to your line manager, your HR department, if there is one. Try and keep it amicable for as long as possible in order to try and resolve things. It really helps to try and keep a good working relationship, especially if this is an issue around return to work, changes to your job during maternity leave, what sort of job you're going to be returning to, flexible work as well, in particular. If you've had a full-time job up until now, and after maternity leave you want to return part-time, and you've put in a flexible work application and that's been refused, really important to talk to your employer about how your job could be done on a part-time basis or in the way in which you're asking for. Keep that good working relationship going. If your aim is to return to work, if you want to convince your employer that your part-time work request or your reduced hours request would work, keep it constructive, keep it practical. Focus on your actual job, how it's going to work, what particular problems your employer might need to address. Obviously, if you're not able to resolve it informally and by talking to your employer, and you feel like you're not getting anywhere, you're banging your head on a brick wall, do get advice. At some point, if you feel you're going to have to pursue it, maybe potentially to tribunal, it's important to raise a grievance, to go through your employer's proper procedures, but don't rush into a grievance. It tends to be treated as a complaint, and that's not always the most constructive way to try and resolve some workplace issues. I think particularly around flexible work and return to work, sometimes around health and safety and pregnancy related issues too. But in some cases, perhaps it's a big employer, perhaps that's the only way that you can get your employer to consider it properly, is to go through those channels. So don't rush into it, but it may be that as a last resort, you do need to ask to see your employer's grievance policy and to raise it as a formal grievance. You need to bear in mind that there are strict time limits for employment tribunal claims as well. And in order to start a claim, you need to contact ACAS, which is the government's advice and conciliation service. It's a free service. And I've given the phone number there. If you're thinking of that this may be going to tribunal, you need to contact ACAS within 3 months, less 1 day from the date of the act or the series of acts that you're complaining about. Now, it's not always that straightforward to work out the time limit, so do take advice on that as well. Now, in some cases, if you're out of time, a tribunal will allow late claims, but obviously you don't want to have to jump through those additional hoops if you can avoid it. So err on the side of caution, contact ACAS if things seem to be going badly wrong. Don't let your attempts to try and resolve it informally or to go through your employer's grievance procedure, don't let that delay things. Ultimately, if you need to contact ACAS to keep within the time limit, do so. What this will start is the period of early conciliation, and ACAS will try and help you and your employer resolve it. And so there will be a 6-week early conciliation period. ACAS will contact your employer, will offer early conciliation, and they may help you and your employer come to a settlement or to resolve the issue, perhaps around your return to work or your flexible work request. If they can't help you resolve it through early conciliation, or if your employer isn't willing to engage, then they will issue an early conciliation certificate, and you will have a month in which to issue an employment tribunal claim. And obviously really important to get legal advice and help with putting that claim form in. And what to do if you're refused SMP? So your best course of action is to go directly to HM Revenue and Customs. They have a statutory payments disputes team, and you can ask them for a formal decision if you've been refused SMP, if your employer is paying the wrong amount, or if your employer has gone into liquidation and is unable to pay it. And you can also ask HMRC, the disputes team, for a formal decision on your entitlement to statutory maternity pay, statutory sick pay, any other statutory parental payment as well, if you are dismissed solely or mainly to avoid paying statutory pay. If we go back to, for instance, the scenario that we had, perhaps you're on a probation period and you think your employer started to raise performance issues, and you feel, in fact, this was pregnancy related, and potentially they ended your probation period and your contract partly to avoid paying you statutory pay. And so you can go to the disputes team and ask for a decision on your entitlement to SMP. So even if you weren't employed right up until that 15th week before your baby was due, you can ask HMRC to make a decision on whether you would have been entitled to SMP had your employer not ended your contract. Your SMP will be based on your average weekly earnings in the last 8 weeks before your dismissal or the end of your contract. And if HMRC decide you were entitled to SMP, they will order your employer to pay it. And HMRC will actually step in and pay your SMP directly if your employer refuses to pay it or they've gone into liquidation. So don't worry, you will get your SMP through HMRC if you've met the qualifying conditions and your employer has refused to pay it or has been unable to pay it because of financial reasons, or they've gone into liquidation. You can get it directly from HMRC. So the time limit for contacting the HMRC Statutory Payments Disputes team is 6 months from what would have been the start of your SMP period, but that can be extended at HMRC's discretion. And so this is the last slide now. I just wanted to flag that during your maternity leave and pay period, you may well be entitled to other benefits. So other benefits like were universal credit, now is the only means-tested benefits for which you can make a new claim, and that's depending on your household income. So important to get advice on that. I know that the Equity Benefits, Tax and Benefits team can give you advice on entitlement to benefits. And really important as well to bear in mind, that's why I stated that wherever possible, if you think you're entitled to SMP, do look into that, because SMP is treated as earnings and is largely disregarded under universal credit. However, maternity allowance is treated as unearned income, and if you are claiming universal credit, it's deducted in full. This means that if your sole employment is self-employment and you need to claim universal credit, you are significantly disadvantaged. Maternity Allowance worked with Child Poverty Action Group, and we challenged the government over the unfair treatment of maternity allowance, and unfortunately the claim wasn't successful. But we continue to campaign for maternity allowance to be treated in the same way as SMP and to be treated as earnings, as it does in fact. The whole point of SMP and maternity allowance is that it should provide some sort of earnings replacement once you've met the qualifying conditions and during your maternity leave period. So obviously really important to get advice about whether you can get additional universal credit or additional tax credits if you're already claiming child tax credit or working tax credit, because you may be entitled to extra help during your maternity leave and pay period. You may also be entitled to the Sure Start Maternity Grant or the Best Start Grant in Scotland. If this is your first baby or your first multiple birth, it is the Best Start Grant in Scotland is also slightly more generous. And you may be entitled to Healthy Start vouchers or Best Start food vouchers if you're in Scotland. So as I've mentioned, really important to contact Equity if you are dismissed or your contract is ended for health and safety reasons, or for advice on tax and welfare benefits matters. We have a number of information sheets on the Maternity Action website covering all of the issues that we've talked about in this webinar, particularly around maternity pay, your rights if you're self-employed, keeping in touch days and working during your maternity leave and pay period, questions around time off sick during pregnancy, during and after maternity leave, your rights during maternity leave and on return to work if you have an employed contract, and questions around redundancy as well. There are some other useful resources, the maternity pay calculator to help you work out if you can get SMP from any employed jobs that you have, or maternity allowance. The link there to the HMRC website for the help that employers can get if they're struggling to cover the cost of your SMP, or if you think that you're being wrongly refused SMP. There's quite comprehensive guidance on the DWP website to SMP and maternity allowance, and there's a maternity allowance calculator for working out your 66-week test period. Now, the Maternity Action, we also have an advice line. We have a national number and a separately funded London service if you live or work in a London borough. And we have an advice, an email contact form if you'd like to contact us for any email advice as well. And that's the end of my section of this webinar, and I will pass over now to Equity.
And thank you very much indeed to Katie Wood from Maternity Action for that great session on your maternity rights. So my name is Victoria Naughton. I'm a tax and social security advisor here at Equity. So that means that I help members with information and advice on many of the issues which Katie has covered today. Our service in the tax and welfare rights team is part of the subscription that you pay to Equity. So please do get in touch with us about your maternity rights. I'm going to spend 5 minutes or so just at the end of the Katie's session here introducing myself and the team. and letting you know how your union can help you with this area. So we operate a helpline in the welfare rights team and the tax team twice a week on Mondays and Thursdays. So you can telephone us directly on those days. I'm just going to put those contact details up on the screen for you. We operate this helpline, on a Monday and a Thursday, and you can telephone us between these times. The telephone number's there for you on the screen. And also there's an email address there. So please do email us or telephone us, leave a message, and we will get back to you and we will answer your emails. So we've also, in Equity, in our team, we've written a guide to maternity, parental and childcare rights. I've put the link to that guide on the screen as well there. We've focused in our guide on the areas which we find members most commonly face. So we've tailored it to those issues. So it's really looking at the self-employed and how to address some of the issues which Katie has mentioned already that you may face as a self-employed person with your maternity rights. So the guide is pretty long, it's very comprehensive, and maternity rights themselves are pretty complex too. So members often want to ask us specific questions about their own situation. So that's really where the helpline comes in, because we can tailor all the information out there and we can answer your questions specifically based on your circumstances. So I answer calls to members twice a week on the helpline, and I thought that you might find it helpful to see an overview and to get an idea of how we can help you. If I run through the most commonly asked questions in relation to maternity rights, which I get asked. So those are here. So these are, on the next slide, the top 3 questions that I get asked on the Tax and Welfare Rights Helpline about maternity rights. So the first question there you can see is, how do I become eligible for maternity allowance? Now, Katie has already covered this, so I'm really not going to repeat her section. But I do just want to say that there's a real take-up issue with maternity allowance. And we find that actually it goes underclaimed amongst members. So we really want you to be aware of it. As Katie's said, you really need to, as a self-employed earner, have your Class 2 national insurance contributions up to speed, and they need to be made and they need to be on your record. So she said that, I'm not going to go through it again. But what I do want to say is that we have found it can be helpful in addressing one of the problems which Katie identified, which is the delay that can be caused from the point of you making your maternity allowance claim to you actually getting a payment. And that delay can be caused by your national insurance contributions making it onto your record. Now, we found that you can telephone HMRC and they can speed up this process if you know what to say when you phone them. So we have included a section in our guide on this, where when you ring HMRC, you want to make sure that your Class 2 national insurance contributions are allocated to your record. You need to ask for them to be put through the alternative clerical exception process, and that they get allocated to the National Insurance and PAYE service. So just a specific thing there for you to ask about. If you still experience problems and delays, then please do let us know. So the second question that I really get asked about maternity rights is about working during your maternity allowance period. So Katie's again has told you all about this, so I'm not going to repeat what she said, but one further point, which is very specific to Equity members, with the restrictions are on work, not on pay. So some Equity members may well be receiving, for example, residuals, royalty payments during their maternity allowance period. Now, those are payments, they're not work being done. So there is no restriction on you receiving those during your maternity allowance period. They won't affect your maternity allowance payments, and they won't stop it or reduce it in any way. It's not work, it's pay. So and that's because maternity allowance isn't a means tested payment. So the third question that I get asked a lot is, what's the impact on my other benefits, or is there any other help available to me when I am on maternity leave? So really, the main thing I can say here is it's a very complicated area. Unfortunately, it's quite difficult to navigate. So really, please come and check with us, check with the Tax and Welfare Rights team. This is the case whether you are new to benefits, you're claiming for the first time, or whether you're already receiving some benefits. So I do just really want you to take that home from my session today. Come and ask if you're going to be looking at claiming or your benefits, or you're already on other benefits. For example, if you're already receiving tax credits, those actually can continue during your maternity leave. You can add on child tax credits to an existing working tax credit claim. So that's just one thing to be aware of. So that's all from me on maternity rights, and that's all from the Welfare Rights team here at Equity. I do hope that you'll use our service to help you navigate this area. As I say, it's all included in your subs, and so please do get in touch, and I look forward to speaking to you. Thanks very much.
Thank you so much for joining us for this video on pregnancy, maternity, and welfare rights. Thanks especially to Katie and to Victoria. Just a reminder that maternity allowance and statutory maternity pay rates change on the 1st of April. So to stay updated on that, keep in touch with us. Equity will also make sure to circulate those rates in due course. But if you have any questions, do get in touch with us via the links posted at the end of the video. If you want to be in touch with us on the Women's Committee, we would love to hear from you. We're at Equity Women. Thank you so much, and take care.